going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Thursday. Yes, Thursday. Happy Thursday. Almost finished with the week. 1 day left. Let's see what's going on. You guys want to watch some court? I want to watch some court. Let's watch some court. So I've got good news and I got bad news. Bad news is there is a giant judicial conference going on in Michigan right now. The entire state of Michigan. So there was very little court to watch today. The bad news. The good news is I was able to grab some clips for tonight, but a little because there was so little court. I noticed I think every one of these videos, except for maybe the last two, have been already played today, which is fine. That's what's to be expected when there are very few courts on. So I did try to put together a video, and like I said, when I was jumping around to see what other people were playing today, I noticed a lot of similarities. But we're still gonna have fun. I hope you enjoy it. That's it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
All right, Mr. Campbell, I'm assuming ready on Mr. Goheen Rango.
That's correct, Your Honor.
Morning, Mr. Goheen Rango.
All right, we all know this guy. This is the 7th or 8th hearing I've covered of his. He's the guy who usually holds up the We the People sign. He goes on sovereign citizen rants from time to time. Sometimes he's a sovereign citizen. Sometimes he chooses not to be. So, yeah, Mr. Rango, let's go.
Mr. Judge Wheeler.
Yep. Go ahead,
And
Mr.
everybody.
I don't, I'm sure Your Honor may recall some of the discussion in last hearings regards to defense's motion for counsel's request to withdraw. I've had opportunity to speak with Mr. Goheen Ringo in custody since that last hearing last week. I still have a good faith basis to indicate there is not a pathway moving forward to repair our relationship, in my opinion. The client, I believe, over my objection, wants to make an oral record of his own. So I'll defer to him if he's going to do that, but did provide him an opportunity for me to provide to the court his presentation to protect his right to remain silent. But ultimately, I believe that there is the perception of an unwaivable conflict based off of the client's statement that I waived his attorney-client privilege, damaging his case. And even if I disagree with that assessment, there are certain waivable conflicts that I am not capable of overcoming these conflicts with the client. In my opinion, I don't believe the client is able of overcoming my concerns. And so those are the grounds upon which I'm seeking to withdraw. I have done a little bit of research on the case law surrounding these types of circumstances where a client is objecting potentially to counsel's withdrawal. I have not. I could, if Your Honor has concerns about that, I can put those into writing or recall the matter. But ultimately, I believe that at this point, my counsel of Mr. Goheen Ringo should be ordered withdrawn, and counsel should be substituted in for his trial in these matters.
Let me ask you. I am going to allow Mr. Campbell to withdraw Mr. Goheen Rango.
Eileen, thank you so much. Welcome to the family. Thank you so much for becoming a member. That is awesome. Thank you, Eileen.
I was present in court when you elicited that attorney-client privilege had been violated, and that you felt prejudiced by that. I don't think we can walk that back. That was on the record and part of the court proceedings several weeks ago. So I'm going to grant Mr. Campbell's motion to withdraw. My question, Mr. Goheen Rango, because I know It had been floated to the court two different ways. One way was that you were choosing to represent yourself now. The second would be if you are asking the court to assign you a new attorney. So my first question is, are you planning to represent yourself at this stage, or are you asking the court to appoint you another attorney?
That's a really good question. That kind of cuts me off of what my train of thought was going. I had a question that maybe should go before that question, but I was just wondering, is that all that's necessary for a judge to remove an attorney? Is that just whether it's true or not? Someone who's been accused of a crime can just simply mention that he believes that an attorney has violated his attorney-client privilege, and that's all it takes to have that attorney removed?
No, because even prior to that time, you were expressing to the court that very day that you believed that Mr. Campbell was not working in your best interest.
Okay.
That apparently that morning there had been some conflict between you and Mr. Campbell of some nature prior to the court proceeding. Again, I'm not privy to that. It sounded like both people.
There was no conflict. There was no conflict.
But again, after that proceeding, after Mr. Campbell's statements on the record, your statements on the record were that your attorney-client privilege had been violated, which is not revocable. I can't ask why it was violated because, again, that's attorney-client privilege. So you invoked that in open court after it was already the perception of the court that the relationship between you and Mr. Campbell had broken down. So again, the court can withdraw an attorney based on the intractability of the relationship between the defense attorney and the defendant. But I think when we add on top of that, also statements that attorney-client privilege had been violated and there was an intractable relationship at that stage, I think that seals the deal. So
I didn't know. I definitely wouldn't have said those things had I known that this would be the consequence.
Laura, you can my Discord channel. That's probably the easiest way to get a hold of me. The link to my Discord server is in the description. Also, my email's on my page. You can always email me. I respond pretty quickly to emails as well.
My concern with it, if I can recollect where my train of thought was that day, was I thought he had mentioned a few details that I didn't want mentioned on the court. I think if I went back,
and again, we're not going to go into that today because if indeed those details were subject to attorney-client privilege, we're not going to restate them and point out to them which ones you thought they were, because again, you would be you'd be invoking things that you said were privileged to the court on the record in open court. So where we are going with this is a very simple question. Are you asking to represent yourself moving forward, or are you asking the court to assign you another attorney?
I think I would like to be assigned an attorney. Now hold on. Actually, if I represent myself, will I have facilities to be able to do that while I'm in custody here, or can I be sent a packet on instruction how to do this? Because I don't know. Might be interested in that.
The court cannot provide you materials in good conscience that are not already available at the Clark County Jail and what is provided there. That would be the court inserting itself into your defense, and the court is an impartial fact finder. The court's responsibility is not to assist people in self-representation. So the issue that this court has is there's a conflict with every existing attorney that this court has with you, or a conflict based on we don't have anyone left. So the court is going to have to explore in the next week whether we can find an attorney in Clark County that will accept representation. I'm not going to
Okay.
go any further than that, but that's the status of the court. So I think we're going to
Okay.
have to set this matter over 1 week, and the court will have to reach out and determine if we can find counsel. Yes, Mr. Goheen.
Is there there's a few attorneys that my mom's been supporting me throughout all this. She's been in contact with. Would it be possible to have them apply personally, or is it just only on the court's behalf to go seek one out? In other words, can one volunteer?
Yeah, that's true. If you go to their website, yeah, I think just about every court website I've ever been on, there's a whole section on self-representation and how to properly do it. He's in jail though, so he's hoping for, like, a printout packet, a little catalog that tells you the do's and don'ts, kind of like when you get on a plane and you have the safety and you're supposed to follow along, kind of like that. Maybe that's what they should give him. Airline safety tips, like, since you're going to be flying soon, here you go.
One that we've been talking with, or
Would have to be a licensed attorney
of course, yeah.
in the state of Washington that has some background in criminal defense. I'm certainly not
Okay.
to have a tax attorney in here trying to navigate a jury trial.
Yeah.
But if there is an attorney that you are aware of that is wanting to accept your defense or availability
Yes, sir.
in court, that's where we'll go. But
Okay. So, and then they just have to show up, or on the Zoom or in person on the next setting.
they would have to contact the court prior to the next setting. The court would have to vet whomever this is, vet their availability, and so forth. So
Okay.
it can't be a surprise guest behind door number 3. It has to be someone who has contacted the court. We're going to see again next Thursday in 7 days, and we'll see what we can do. Okay.
And Your Honor,
All right. Thank you, Your Honor.
I just wanted to check our speedy. I don't have the commencement right in front of me.
I want to say is April 17th.
Okay.
So we are going to be 30 days elapsed.
Great,
Mr.
okay.
Goheen Rango is not being held on these matters. Let me look though. I remember that the waiver, let's see.
I have it entered.
April 17th,
Okay.
2025, entered February 20th, 2025.
Thank
So
you.
we are 32 days elapsed next Thursday, the 15th. Ms. Carmi, do you have an objection of this matter coming back next week? I know that you are not personally going to be present for, I suppose, the assignment of counsel. My recollection, if we have withdrawal, is that speedy trial will recommence with the assigning of a new attorney.
Yeah, I have no objection to this being heard next week.
Okay. All right, Mr. Goheen Rango, we are going to see you next week, sir, and we will work on getting you counsel. Thank you.
Thank you, Your Honor.
Yep.
Thank you, Ms. Carmi.
Thank you.
Thank you, Brandon, if you're still there.
Ashley,
All right, that was just a quick follow-up of our good friend, Mr. Rango. Is it Ringo or Rango? I feel like they used to say Ringo, but the last 2 hearings they were saying Rango. I don't know. All right. Anyways, we are moving on. The next one is actually same judge, same court, just a few people later. I think it was about 5 minutes later. Now we're in for a treat. Let's go.
all right,
You
Mr. Campbell, ready on Ms. Pickett-Kennick?
Yes, Your Honor.
All right. Ms. Pickett-Kennick, can you hear the court, ma'am?
Hey, Caroline, thank you so much for the 5 gifted memberships. I appreciate it. Welcome to the 5 new members. Thank you so much, Caroline. That is awesome.
I fired my attorney last week, so I don't even know why he's over here trying to represent me. And that's why I have a warrant, is because he fails to understand that I fired him and asked for a continuance.
Understood.
His office is not representing me to the best of their ability, and that is why I fired him.
Okay, go ahead, Mr.
No, this is it's Battleground Court. I don't know if it's municipal court or not. I think it's just Battleground Court in Washington. You can, if you're on YouTube, if you just type in Battleground Court, this court will come up. They stream, I think, 2 days a week. they'll have an AM and a PM docket twice a week.
Campbell?
Your Honor, the client is indicating that she would like to terminate my services. I have indicated to her that I think it's unlikely that Your Honor will rule on that motion until the 1077 evaluation is completed in this case. This matter was last in court on April 24th. The client made an appearance on April 25th in Superior Court and was sentenced on a Superior Court matter. So that is one factor I would note for the court's consideration. The client had an appearance the following week scheduled in our court. I'm not saying she didn't appear, but a warrant was issued. Now she makes her way before Your Honor. I believe Mr. Schoonover has indicated that she is amenable to potentially out of custody restoration. But we need to get an evaluation completed. I think.
Your Honor, I spoke with Brian the day I left custody, and I actually had an appointment, then got arrested. So my attorney is not doing his job at all. He's sitting there fumbling with his words.
I haven't received further information from Mr. Schoonover. What she's saying may be completely accurate, that she had a future appointment for an out of custody evaluation. Those usually take some months, Judge. So I'm not sure.
Your Honor, Mr.
Yes.
Campbell needs to actually change his website because he doesn't help victims, he causes victims. And I really would like him off my case because back in October of last year, he gave me paperwork on
Ma'am, I
the
wouldn't
trespass.
recommend speaking on the docket any
I
further.
recommend you stop speaking for me because you're not helping my case. Your Honor, back in October of last year, Mr. Campbell handed me paperwork on the trespass. It is a business trespass, not my son's address. This all could have been resolved back in October of last year.
So Ms. Pickett-Kennick, do you know the next steps in regards to the out of custody
Hey, what's up, KCC? Good to see you.
evaluation then?
Yes, I talked to Brian's my son. I talked to Brian the day that I got released. Your Honor, the things that are going on out here in custody are just, it's guerrilla warfare, and I'm not playing anymore. It's not. Anyways, I just have to pick up the phone, call Brian, and he's going to do it. He came in and did a competency to see if I was competent the day I got released. And I just have to call him and make the appointment. It's not going to take months. It's only going to take days for me to get in there. And I also have wraparound services to get into housing through CMAR. All that has been set up. If everything would stop being meddling with, I could actually get my life on track. Your Honor, I am trying. But there's guerrilla warfare going on out here with these patriots, and I'm not playing. I have mental problems. I have anxiety, PTSD, and bipolar, yes, and they're all being treated and have been for quite some time. I went through EMDR 3 times. I went through counseling 3 years. I am sound mind and cognitive. I just need people to let me do me and let me get with everything that has been put in place to actually get my life in place, Your Honor. And I really want Campbell off of my case. He is not. Go look at his website. That is so not even, that's not right. You're causing victims, Brandon. You're causing victims.
Ms. Pickett-Kennick, we are going to release you.
I think this is the origin story for the 100 men versus one gorilla meme that's been going around. We found it. We found the start.
On your hold today, we are going to schedule a future court date for you, ma'am, on June 26th, 2025 at 10 a.m. We're going to get you some paperwork in regards to that court date over at the jail. I did sign off on the competency evaluation order, so hopefully we get that taken care of. It sounds like you know the next steps on that. And
Yes, Your Honor, I do.
Thank you, ma'am.
Thank you,
Judge,
Your
if I could
Honor.
just briefly give the client some information. Ms. Pickett-Kennick, stay in contact with Brian Schoonover. He is not the
Talk to me.
evaluator.
Do not talk to me, Brian.
It may be beneficial for the client to get new counsel, Your Honor. She has to be able to participate and communicate with counsel in order to be able to facilitate the evaluation, because the out of custody evaluator will email myself and possibly Brian Schoonover, and then Ms. Pickett-Kennick would need to cooperate with counsel in scheduling that evaluation. And so I don't know what to say.
I don't either. Ms. Pickett-Kennick, can you at least work with Mr. Campbell to get the evaluation scheduled, ma'am?
Yes, I can work with him to at least do that, Your Honor. I can at least do that. Or his secretary, yes, Your Honor, I can.
Okay, let's just leave it at that for now. And if we still have conflict after the evaluation, we can then get you a new attorney. Okay, ma'am?
All right, thank you so much, Your Honor.
Thank you.
All right, that was fun. I've got a special presentation. Something that was just sent to me. Hold on. Let's make sure it loads.
For all of those who are looking to watch some court cases, I'll be back on the bench on Monday, and so will a lot of other judges. The state Supreme Court conference, judicial conference, is happening this week, and so that's where everybody's at. So enjoy, and God bless America.
Just checking in with Judge Slavin. Thank you, Judge Slavin. Sent from an undisclosed location. Yeah, but yeah, I said that in the intro. Everyone's fighting over the same few courts today. That's why, if you've seen the videos, I apologize. Not really much we can do about it. But anyways, let's keep moving on. What's next? I don't know. Judge Boyd, let's go.
He's asking to be allowed to work. Are you all in agreement or no?
Your Honor, I believe we did hear this and the court was just wanting proof of employment and
Yes.
defense counsel did provide that.
This was directly from the pretrial service officer as well.
Okay. Okay, all right, let me just
I can kind of see that. He also, if not only did he become a lawyer, he lost some weight, so good for him, and he somehow found the fountain of youth, because this attorney looks like he might be 30.
explain. I'm a little bit confused by the document, or maybe I'm interpreted incorrectly. All right, State, do you agree that the hours he works are from 9 a.m. to 8 p.m. Monday through Saturday?
I mean, I don't agree, Your Honor, because I don't know. My understanding was that was his personal business.
I did not know that. I did not know that. So my joke was not very good. I apologize. I didn't know he passed away. Sorry.
Is that
Is this your personal business? And what do you do?
Like think of Geek Squad.
I'm sorry, what?
Think Geek Squad. I'm a computer guy. I repair computers. So I have a PO box where I go pick up computers and I go to people's houses and I knock out computers, whether it's businesses or computers, and not to mention that I work for another company that does ATMs. So I do Rocket Criminal, which is Bitcoin ATMs. So
I'm sorry, you need to speak up.
I also fix ATMs. So you think like, I'm not sure if you know about Bitcoin, but Bitcoin ATMs, that's what that is as well. So I have a contract with a company that does Bitcoin ATMs where I have to move. That's the reason why I'm asking.
All right, so what I can tell you is, one, I didn't know this was your own business. This 9 a.m. to 8 p.m. doesn't work for the court. I'll allow you, well, I mean, this is what I'm telling you. I'm not doing 9 a.m. to 8 p.m. and 10 a.m. to 8 p.m. I'm not doing it because the hours that you're posting, these are hours that you say. I don't have any proof that this is actually occurring. All I have is your word saying, I'm going to a PO box to pick up computers, and I do this from 9 a.m. to 8 p.m.
And I also work at houses.
Well, again, this is from 9 a.m. to 8 p.m. I don't have any proof of that. All I have is you're saying it. And I'm not going to agree to a time from 9 a.m. to 8 p.m. That's more than 8 hours a day.
Your Honor, an alternative, my client would be able to limit his hours to a traditional 9 to 6, 9 to 9, or I guess it would be 8 to 6, just to give him that window, be able to travel.
I'm not doing, I'm telling you, if I allow him to do this, it's going to be normal business hours. It would be 9 to 5. And even when I'm doing it 9 to 5, he needs to have documentation that he actually went to a PO box. The time he is going to that PO box, he needs to provide it to them.
I don't know how. Just go to the field box, you're supposed to. This is the problem that happened with the GPS officer in the first place.
So here's the thing. This is what I'm telling you.
I'm not trying to be.
And no, I don't take it as being difficult. I understand that you want your hours to 9 to 8 p.m. The state is saying they don't want you to have it at all. I understand why the state is saying no, because you're on bond for continuous violence against family, violation of bond or protective order, assault and stalking. So here's the thing, whether it's true or not, I don't know. All I know is what your charges are. All I know is my job is to protect the community. All I know, at least one of them, all I know is your attorney is saying that you can't pay for this GPS because you're on full house arrest. So this is what
No, he said he's self-employed, but think Geek Squad. He used Geek Squad as a example for what he did.
I'm sorry?
I can't pay for anything right now. I'm about to be homeless.
Yeah.
This is why I need to work.
All right. I will tell you this.
I need to work Sundays too, and I need to. And if I'm
Well, that's not going to happen.
Your Honor, if we can ask that it be modified to the 9 to 5, my client will provide the necessary proof at this point. If that is the court's order, he will abide by the court's order. And I will make sure that he understands that that is the court's order at this. It is better than nothing at this point, because he does need to get to work, Your Honor. He is going to be homeless soon if he cannot start making, money. He's made current arrangements with his landlord to allow him to stay there. But he is behind, I believe, a month or 2 months behind rent already.
I need to leave. He's already given me a termination on my lease, so I need to get out of there. So I got to be able to generate something. And maybe I was asking for just tracking only so that I can move around.
No, tracking is not going to be allowed. That's not even a consideration.
Can I speak? I don't know.
You can speak, but I'm telling you.
No, I'm just going to ask a question.
Sure.
I'm asking a question. So I was told the other day by the DA that I'm going to listen to you. You don't know what I'm not going to say.
No, I'm listening. Go ahead.
I'm not going to talk.
No. Here's the thing. I will tell you, I keep an open mind. The issue that I have with you is that the timeframes he's asking for, there's too much of an open window. And basically, if I allow him to do this, it is sort of like tracking, because he's saying he's working from 9 a.m. to 8 p.m.
Yes, sir.
I don't know if he's going to a PO box or whatever. Somebody would have to ask the pretrial services to do that.
I need to generate money.
Your Honor, if we can, like I said before, we are willing, if the court is only allowing him to work from 9 to 5, my client will make the necessary arrangements for his business to be able to work within those hours that the court allows. We are asking that it be modified to allow that at least. He will just need to have to modify his hours at that point.
All right, so this is what I'm going to do, and I want you all to write this up and state, I know you're not in agreement with it, but I'm going to want this written up. So his hours that he's allowed to work are from 9 to 5. That includes.
They said some kind of family violence, but he was on bond for the original charge, and he violated his bond somehow. So he's on heightened conditions, is what's going on. But all Judge Boyd said is family violence.
Going and coming. He is going to have to pick a specific time when he is going to be traveling to go to his PO box. And he needs to put down the location of the PO box. And in these hours from 9 to 5, Monday through Saturday, he needs to put in the order the time in that block of time that he is going to be traveling to his PO box. And if somebody calls him and they want a computer repaired, he needs to call pretrial services to let them know, I've received a phone call. This is the specific address that I'm going to either pick up a computer or repair a computer at this address. And he needs to tell them how long he's going to be at that address. Yes.
How about when pretrial don't answer because they never answer? I can't even speak to my pretrial officer. He
Send an
doesn't- he-
email.
Your
I
Honor,
have proof of all the emails I've sent to him.
Well,
Your
yes.
Honor, if I may,
Mhm.
if I may, I understand the court's order. I know he needs to give documentation. I know he needs to tell them that he's gonna go. But sometimes, as he is saying, there is time constraints of when,
I'll just put it in an email. It's a paper trail.
of course, Your Honor, so he wouldn't need confirmation from them to say, yeah, you can go there. It would just need to provide documentation of proof. This is where I'm going.
This is what the court's order is. He needs to sit down with you. And for each Monday through Saturday, his time he's allowed out is from 9 to 5, and has to be work related only.
Of course.
So for example, on Monday, if he says, I'm going to go to my PO box at 10 a.m. and he needs to pick that date, not I'm going at 10 a.m., then I'm going at noon. No, just pick one block of time that he's going to his PO box. In the order, put, defendant is allowed to go to his PO box on Mondays hypothetically, it's 9 a.m.
Mhm.
At 9 a.m., the PO box is located at this physical address. He's only allowed to be there for.
Sir, please. Every
Who's to
time
say?
you open your pie hole, you get it worse trouble. So stay the course.
Whatever he needs from that PO box. Now, mind you, sometimes people are standing in line. It's something that the postmaster who's in charge of that location has to give it to you. That's fine if he goes beyond that point, but at least the GPS will show that he's at that location at his PO box.
Okay.
So he's only allowed to go to that PO box once a day, pick whatever time he wants to pick it. And then if he has somebody who calls him and says they need a computer repaired at their home, he needs to get that person's address, email or call GPS and said, I'm going to go repair this person's computer. This is the address.
Okay.
And when he goes to that address, when he gets ready to leave from that address, because the GPS should show I'm at 300 De La Rosa and I'm still here repairing a computer. When he gets ready to leave from repairing that computer, he needs to send them an email and said, I completed repairing this computer, or I'm leaving this location, and then he goes back to his home.
Okay.
So if y'all can.
Can I stop and get something to eat?
No,
I can't
Just
stop
for
and get
work.
something to eat.
that's what Uber, don't they have Uber Eats or something else that happens? They
And
have
who can
delivery.
afford that when I can't work?
Mhm. All right, let me just tell you, here's the problem, and I want you to internalize what I'm saying.
I am.
No. I mean, seriously, internalize it. I do not take any of these charges against anybody as true. I don't take it as beyond a reasonable doubt because I haven't seen any evidence. But my job in this part of the process is to make sure that the community is protected. Part of your problem is you're charged with continuous violence against a family member. You're charged with violation of a bond or protective order. And when you have a violation of bond or protective order and it's in felony court, that means that there are extenuating circumstances against that. That means that somebody allegedly has told you before, this is a protected class of people, you're not to be around them, and allegedly you violated. Then I have assault stalking.
They
So-
violated. I
so-
didn't violate them.
Then we have this assault stalking thing. So
Yes, sir.
that person will be very concerned. And so do I consider the complainant? Yes. Because at the end of the day, the complainant, whether what they're saying is true or not true,
Sure.
they don't want to end up at some store and then all of a sudden they see you.
If I can give some context, just
Yes.
on my client's behalf, because I know he's wanted me to say it at this point.
Sure.
Is that the complainant has submitted two different I believe, affidavits or statements to the DA's office where she has recanted her story, as well as the mod modification has been modified to a no harmful and injurious contact. So I believe my client, I think what he's trying to get at is when we were talking about tracking, or when we're talking about the GPS, I think his position or our position is that there wouldn't be a, I guess, harm to the community because the complainant is on board with him.
Hey, another Colin. Welcome.
And working and getting to.
Well, let me ask you this. Have
She's
you
right-
received
she's
all
right
this-
outside.
Have you received all discover? Do you want to talk to her? She's right outside.
She's right outside. She's sitting right there.
The court knows sometimes the state has to step in to protect the community.
All right, so this is what we can do. We can set this for trial next week if you all want to trial. I'm here. You're here. The state's here. I can put it on
I
trial.
believe we're close to an agreement. We've been conferring on the matter already.
Well, I mean, if you all want, I'll call you back May 13th for a jury trial. You can either do a jury trial, bench trial.
I'm not
Let me
scared of
explain.
none of that. Nothing happened.
No, what I am telling you is, and this is the problem, I don't know why you won't listen. That's part of your problem. You don't listen. Now,
don't even
what
know.
I'm telling you is, I will bring this back on May 13th. You can either have a bench trial or a jury trial. Will you be ready for jury trial on the 13th?
Your Honor, there is another.
There's another case, Your Honor. We are trying to, we're close to wrapping all these cases up in a global offer. We would just ask that the court give us some time.
On May 19th, Your Honor, when we're coming back, on that day, we will have the answer whether
Right,
this
but-
is going to be a plea or a trial.
But what's the other trial?
Jurisdiction, right, Your Honor.
All right, so then I have that to work with. So this is what we're gonna do. We're bringing back this on May 13th. That'll be your jury
Did you hear what the other charge was? A terroristic threat. Wow, that's all I'm going to say. Wow.
trial date. You can, the witness can come, not come, whatever is gonna happen. May 13th, jury trial.
Thank you, Your Honor.
All right, thanks. Ms. Ferguson, give them a date for jury trial, May 13th.
All right. Let's move on. Was it domestic, Mike? Did he say domestic? I thought he said terroristic. All right. Before, real quick, Phil, thank you so much for the gifted membership. I appreciate it. Welcome to the new member. Thank you so much, Phil. That's awesome. All right.
Mr. Thompson, you're here today to be arraigned on 3 misdemeanor charges brought by the city of East Lansing against you. They allege that on April 19th, 2025 at approximately 11:12 p.m. in the city of East Lansing on Abbott Road at or near Saginaw Street. The first misdemeanor charge against you is that you drove while your license was expired. The second misdemeanor charge against you is that you failed to produce proof of insurance. And the third is that you engaged in disorderly conduct by obstructing, resisting, or hindering an officer. The driving with your license suspended is punishable by up to $325 in fines, up to 90 days in jail. The failure to produce proof of insurance is punishable by up to $220.
I don't think so, Jedi. When I heard the charges, though, and my ears were perked up. It's like, wait a second. Expired license. What do you say? No insurance or no registration, and then resisting the officer. I'm like, oh, this has soft sit written all over it. And then in a second, he's gonna call an attorney. He calls lawyers agents. So it's like, oh, this guy has to be a soft sit. But then he doesn't do anything else. So I'm gonna spoil it now. I don't think it's a soft sit, but yeah, let's just go.
$25 and 90 days in jail, and the disorderly obstructing, resisting, or hindering an officer who you knew to be a police officer performing their duties is punishable by up to 93 days in jail, up to $500 in fines. You have the right to a lawyer. Are you planning on hiring your own lawyer, representing yourself, or would you like to have the public defender represent you at either no cost to you or a low negotiated cost to you? That's between you and the public defender's office, because you have the right to attorney. Which option would you like to exercise?
I will be obtaining and retaining my own agent.
Okay. Do you know the name of your lawyer? Is it someone you've used before?
No, I don't know
Okay.
currently at this moment.
So you'll be hiring someone.
Yes.
Okay. All right. You have the right to remain silent. You shouldn't say anything about the events that were involved in on the night of these three charges. You have the right to a jury trial, and along with a jury trial, you have some important constitutional rights. You have the right to cross-examine the prosecutor's witnesses. You have the right to call your own witnesses. You have the right to testify on your own behalf or to remain silent. And you have the right to be presumed innocent unless you're proven guilty beyond a reasonable doubt. Generally, when people are not represented by a lawyer at their arraignment, they plead not guilty so that they have some time to talk with their lawyer about what to do next and how to plead. So how would you like to plead, sir?
I plead not guilty.
Okay. All right. We're going to set a pretrial conference for May 29th at 1 p.m. A final pretrial conference, if your case is not resolved at that first one, will be July.
You said May 20, excuse me, Your Honor. Yeah. You said May 29th at what time?
1 p.m. And then if the case isn't resolved at that first pretrial conference, a final pretrial conference will be July 14th at 1 p.m. And if you are taking this to a jury trial, which is your right to do, your jury selection will begin on July 15th at 1 p.m. Now, it's my obligation, Mr. Thompson, to set your bail, and because you have Ms. Vachon here, you can ask her to represent you for just purposes of the bail setting. These are three misdemeanor charges. I don't know, because this is just an appearance ticket, what the facts are regarding
I received a notice to appear for two things. I didn't receive a notice for three things. I got a notice right here in front of me for driving while license expired and disorderly,
obstructing, resisting, hindering.
Yeah, so I just want to know, how could some rookie cadets, charge me with disorderly?
And I have just what I was about to say in terms of setting.
You got some 22-year-old teenagers basically with firearms, pumped up on Red Bull, look like their nose a little bit powdery, saying that I'm resisting when I'm being pulled over for a civil infraction due to a payment for a child. So me resisting anything just doesn't even seem fit at the end of the day. So I would like to exercise my right to examine everything. I definitely would like to see body cam. I would like the body cam footage from the officers from the scene. I definitely would like the officers drug tested as well and put on the ready list.
Okay. You have the right to discovery and to see the body cam footage. Yes. I know none of the facts, the ages of the officers.
They were 22 years old, each one.
Let me finish for a second. Okay. I don't know any of the facts because I just have an appearance ticket. There was not a warrant issued with this. There are a couple of different ways for officers to bring misdemeanor charges. One is to actually fill out a warrant stating all of the facts, like whether the defendant ran or refused.
Yeah, I've never heard anybody ask for that. Can we please have the officers drug tested? I'm going to guess as an officer, you're already randomly drug tested. Just a guess. I don't know. I imagine so, though. If you ask for it, that was probably what they say. It's like, oh, it's department policy to randomly drug test every so often. So, nope, we're covered.
To give their real name, all of those are just examples. And you shouldn't say anything about that night because this is being recorded and everything you say here today could be used against you at trial. But I only have an appearance ticket that says what the charges are. It doesn't give me any of the facts. So those are things you're going to want to explore with and through your attorney. And you can have your attorney make discovery requests through the city attorney, and they will turn over to you all of the body cam footage and the information that the police have. That's sort of part of the due process that you're entitled to. But you shouldn't talk about it here because this is recorded, and the prosecuting attorney can use anything you say here to cross-examine you. So it's now my obligation to set your bond. And when I'm setting your bond, I have to determine whether or not you are a flight risk or whether or not you're a danger to the public. You have Ms. Vachon here. I'm going to, because she's a public defender that's well known to this court and very competent, let her talk to the court about your bond. And specifically, Ms. Vachon, I'd like to know whether or not Mr. Thompson has any outstanding warrants for failure to appear in any other jurisdiction.
Your Honor, Mr. Thompson declined to speak with me, so I do not have specific information to provide to the court. I would request a personal recognizance bond on his behalf, given that he appeared today as ordered. He seems committed to continuing to appear, and these are all misdemeanor offenses.
Okay. So do you understand, Mr. Thompson? She's asking for a personal recognizance bond, which means that I don't make you pay any money to stay out of the custody of the court. That's pretty typical in a misdemeanor case, especially when they're nonviolent, although I don't know whether the obstructing, resisting, or hindering involved any physical acts. And you shouldn't say anything about it right now, really, honestly. Have you ever...
Hey, what's up, K4? Good to see you.
Ever failed to appear in front of another court?
No.
Okay. And do you have a lease or a mortgage or a job or anything that ties you to this community that gives me security that you'll appear for all those dates that I set, your pretrial conference and your final pretrial conference?
Yes.
Okay. Can you tell me specifically? Is your name on a lease or a mortgage or either one?
So Mark and K4 come into the chat together. Where were you guys just hanging out at? What party was I not invited to? What's up, Mark? I'm joking.
I pay child support. I can't go nowhere.
Okay. Do you have a job here in town?
Yes.
Do you have family here in town?
Yes.
Okay.
Born and raised here for 42 years.
Okay. All right. I'm going to just order a $500 personal recognizance bond. That means you don't have to pay anything. You're released on your personal recognizance. But because the allegations are that you drove while your license was expired, I'm going to make as a condition of that bond that you do no unlawful driving, which means that...
Excuse me, that I have a contestment to that because that's how I work. I'm employed. I drive for employment.
Okay, we got to...
Wait, K4, did you raid me? I can't see it. I don't have the YouTube chat open, and StreamYard doesn't tell me that. So, K4, if you rated me, thank you so much. Now I see what happened. I wasn't invited to the K4 stream party because I usually raid you, not the other way around. So, thank you so much. I appreciate it.
Get your license. You got to get your license up to date before you drive.
The reason why my license is suspended is not because I haven't paid anything. It was due to a child support contestment, and I've contacted the offices and we have consolidated that matter. So I'm just waiting for some papers from them, and then I'll be able to take care of that. So making any restrictions on my driving would prevent me from being able to earn income.
But I can't allow you. The first condition of all bonds is that you can't violate the laws of any
I'm not violating the law.
Okay. All right. So no unlawful driving, $500 personal recognizance bond. We'll see you at your pretrial on May 29th at 1 p.m. Thanks to all of you.
Talk about my driving.
Okay, sir, you're all set to leave. Thank you.
Thank you.
Fuck you.
Ooh. Yeah, that's going to be an interesting one if we get the next case of that. Yeah, I don't think that guy's a soft sit. I don't. I think he had potential with the charges and him calling the attorneys agents, but after that, he just had attitude. That was it. All right. Anyways, let's move on. We're jumping down to Texas with Judge Garcia, and we've got a serious case here. This one's not a funny one; it's serious. But I didn't want to end it with that, so I do have a slightly feel good clip after this one. So don't worry.
Shannon, Diego on this side and Daniel on this side. Or I think Shannon is on Zoom. Shannon, if you want to unmute yourself.
Thank you, Your Honor.
Yeah, you can stay on that side. Okay, give me 1 minute.
This is a rare case where you see Judge Garcia getting angry. That's why this is in here. Judge Garcia doesn't usually snap, and she does not like this guy.
Okay. All right, Miss Shannon. So I've read your email. I kind of got the drift of what's going on.
No, it's not a no. It's a happy clip. It's not like everyone's gonna cry type of clip. No, it's not that kind of feel good clip. It's yeah, it's just it's only like a 2-minute case, and yeah, you'll see. It's don't worry.
Have you gone to the Justice Center? Have you filed any protective orders?
Yes, ma'am, through legal aid.
Okay, and where are we at on the protective orders?
I haven't heard back from them yet. I know there's
Okay,
a no
when-
contact right now.
When did you file?
2 weeks ago, ma'am.
Okay, and what did you say?
Oh, Sparkle, I forgot. I missed your first one. I didn't miss it. I just forgot to read it during the break. I'm gonna guess that means DIY. Are there DIY books for stalking, asking for her friend? I don't know. I don't know. I'm just gonna say thank you for the super chat, Sparkle Boots, and move on. Thank you, Sparkle Boots, and a second one. Warning: Colin get a feel good clip. Yes, warning. Don't worry, it's not my typical feel good clip. Don't worry, Sparkle Boots. Thank you.
About a no contact?
There's a no contact order. He just got
And
out of
it's been
jail.
signed by the judge.
I believe so. That's what they told me. That's a police officer.
Do you have any proof of that?
No, ma'am. I'm
Because
sorry.
if they signed a protective order, they had to have given you a copy of it because you need it.
They didn't give it to me. No.
So we have no signed order yet. So as of right now, I don't have a signed order. All right, go ahead, Miss Shannon. Are we asking for rent?
No, ma'am. I just want him out.
Okay, and you do own the house, is that correct?
I'm the renter. I'm rent. That's why I provided you my lease.
Okay. So where's the owner in all of this?
The owner he's unable to attend today, but he's already he's called the police on Daniel himself.
Okay, so he's aware of the situation.
Oh, very much so.
Okay. All right, Mr. Daniel,
Yes, ma'am.
are you on the lease?
There was never a lease. She just got a lease recently.
So were you on that lease?
No,
Okay, so I asked you if you're on the lease. You said there's no lease until recently, so there is a lease.
I've never seen a lease. She's never shown me a lease or.
Why should you?
Okay. All right, so you're not on a signed lease, so you have no obligation or no rights to this apartment, is that correct?
It's a house.
It's a house, okay, house apartment, I'm sorry.
Okay.
Do you have rights to this house? If you do, show me some paperwork.
Okay, well, this is paperwork for the owner because I have an eviction process already going through this court. Okay,
Why do you have an eviction on going through this court? Or as you filed the eviction?
no, I have for a different address location. It's gone to the Fourth Court of Appeals. They sent them.
He has a prior eviction, Your Honor.
Okay, everybody stop, go ahead.
For it to go back to the lower courts.
Okay, Mr. Daniels, I need to show proof that you have rights to this house. I'm not talking about another case that's in district court. We're talking about this case that's in front of me. Do you have rights to this apartment or house, whatever it is?
Well, I have the police reports and the address. See, I'm trying to get an address so I could have a garage sale, which
Okay,
the permit would not let me. She allowed me. in the house.
Mr. Daniel, do you, again, for the third time, I'm not talking about a garage sale,
Okay,
okay? I'm talking about the legal rights to you be in this house. Do you have any paperwork, any signed lease, anything from the owner stating that, okay, Mr. Daniels, you can stay in this house?
no, ma'am,
Okay, so you don't have any rights to this house.
that is correct.
The person that does have the rights to this house don't want you there.
She never gave me a notice to vacate.
Okay, so let's start with that.
I gave him an oral in January and in March. He's had two
All right.
oral.
Ms. Shannon, an oral, have you given him any other notice to vacate besides verbally telling him that?
Just a summons from the court. He was
Okay.
provided with the court for the eviction.
All right, Miss Shannon, I cannot proceed forward if you haven't done the notice to vacate properly. Just an oral notice to vacate is not legal.
What?
There are certain ways to do a notice to vacate. And I can't give you a judgment if you have not done it properly. Just like everybody else here in the courtroom, they have to follow the rules. I will get in trouble if I give you a judgment and you did not do the notice to vacate properly.
But you were satisfied with it when you set up this court date and filed for eviction. It states here an oral is acceptable on the
There,
application.
because first of all, my clerks are not attorneys, so they're gonna accept any filings. I'm the one that makes the decision,
Yes,
so it
ma'am.
comes to court. So let's stop you there as far
Okay.
as me accepting it. I accept all filings, whether they're correct or not. That's why they come before me, so that I can go through them and make sure that they're done correctly. And an oral notice to vacate under the property code is not valid unless you can give me a rule stating or a statute stating otherwise. I will be glad to entertain that.
I'm
But
not a lawyer,
until
ma'am.
then, as far as I know, an oral is not valid enough.
Well, under the circumstances, can you award me
I can't. I'm
eviction
sorry.
because of the court order and him
Okay,
assaulting my son in my home?
okay. So Ms. Shannon, I can do one of two things. Okay, I can reset this for 1 week so that you can show me a signed protective order from a judge. But other than that, I'm gonna have to dismiss this case and you're gonna have to start all over again. You
Okay, the
want the
protective
1 week
order-
reset?
Yes, please.
Okay.
I'll get it to you today. Will you make the decision today if I get it to you today?
Yeah.
I will get that
Well, I
right
can't
now.
make a decision today. I have to have them present in front of me, but I can reset this. As soon as you give me the order, I'll find the next court date because I understand your circumstances. I do. Okay, but give me 1 minute. Mr. Daniel, I'm gonna tell you this one time and one time only. I don't know what's going on. I got a gist of what's going on and I'm not liking it at all. So again, I'm hearing one side, but I got a protective order fixing to come, and that protective order will trump this eviction. And I'm telling you right now, whatever's going on, you're gonna end up somewhere you don't want to be. Okay, I don't need a response from you. I'm just simply telling you, I don't need any response from you. Okay, you can save that for the judge for the protective order or any sheriff or constable. But I'm telling you right now, if these things are correct, then I will put a notice to the SAPD myself. Do you understand me? You better keep your hands to yourself. That's it.
Okay.
I don't need a response from you.
Ma'am.
Keep your hands to yourself. 1 week reset. You're free to go. All
Thank
right,
you, Your Honor.
You got 1 week. Okay, thank you,
Yes,
ma'am.
Yeah. Yeah, it doesn't seem like a good dude. But as Judge said, one side of the story. Man, I wish she had some help so she was able to do that correctly. I see why she's upset. But yeah, she didn't do it correctly. And with all the oral going around, yeah, I don't know. Anyways, all right. Let's get to the last one. This is just a happy clip. I'm not even going to use the word feel good anymore. Because you guys, yeah. Anyways, Phil, thank you so much. Feel good clip tissue fun. Thank you, Phil. You're not gonna cry. You're not gonna need the tissues on this one. You're not gonna need it. This one's short. Let's go.
with you in a moment. All right, either you're Hannah Omar or you're not, and if you're not, you can be here for no reason. All right, good morning, Ms. Omar. You understand your rights?
Yes.
Did you get a copy of your ticket?
Yeah, but
Did you read it?
Yeah.
But you don't understand what it is?
Not exactly because
So basically, you got charged with the flip side of a speeding ticket. You're charged with the name of the offense is failing to maintain an assured clear distance ahead, which is a fancy way of saying they claim you were going at a speed at which you were unable to come to a stop before striking an object in front of you. It's a minor misdemeanor. It's the least serious level of offense here in the municipal court, and the maximum penalty is up to a $150 fine. So there's no jail, there's no license suspension or anything like that.
right.
Understand?
Yeah, they gave me $128.
Right, right.
Thank you, Jedi. Enjoy your chicky nuggies. Appreciate the super chat.
That's if you had waived it.
Yeah.
But by showing up today, you have the option, if you'd like, of entering a plea of not guilty, and we'll set it for a trial, and the state will have to prove it beyond a reasonable doubt. If you end up pleading guilty or no contest, by being here in person, you're going to get extra time to pay your fines and costs. So how would you like to plead? No contest? All right. Did you understand the nature of a no contest plea based upon my explanation?
It's basically
You're not
guilty.
admitting guilt, but you're admitting that what they say happened is true, and here's what he wrote, just so you know.
Actually, it was crazy because the car in front of the speed limit was 65, and we was both getting off. The guy apparently ended up working at the same place. He went in front of me, and apparently the car in front of him stopped, and I'm traveling 65, and the way he went in front of me, I couldn't stop, so I ended up hitting him.
Okay, where do you work?
Securitized, but I work for Turner Construction.
That's your location right
Yeah.
now? Did you know that guy who was up here earlier who
I
said he
heard
works
him,
for?
but no.
Don't know? Okay.
I've been with the Securitized for 9 years.
Oh, really? Okay.
I got a 6-year-old, so.
Any interest in becoming a law enforcement officer?
I thought about it.
But no?
I would, but I thought maybe I'm too old to.
You should talk to her when she takes you down to the clerk's office.
Really? Okay. I would love to.
She has a long history of first responder involvement. Okay, so you remember how I said at the beginning how your case isn't going to magically just go away by you not doing anything? Well, there's always an exception to every rule. So our local rules require an officer, when they file any type of charges, whether they be criminal or traffic, to file what's called a statement of facts. It's so that it's beyond just the ticket. I need to know what they say happened. Now, in your case, they did have a couple of witness statements in here, but there's nothing from and I don't even know what agency it was. I think it must have been it says Department of Public Safety on it's Highway Patrol. Okay, so this officer, this trooper, did not file a statement of facts. So I have no idea what happened here, and without a statement of facts, because it's a violation of our local rules, the ultimate result is that the court will dismiss this. All right.
So thank you.
Now, theoretically, they could reserve you. I doubt very much that they would. But if I were you, on your way home or wherever you're going next, buy yourself a lottery ticket because it's your lucky day. You have any questions?
No, I wish I could hug you.
You're not allowed to do that. Mrs. Stansbury is a very jealous woman.
All right, Shane. Depending on what judge you're in front of, that might not work, but maybe it would. If you're in Michigan, yeah, maybe. Anyways, that is the show, guys. That is it. Thank you so much for hanging out with me tonight. More tissues. I really like this judge, and he's awesome. He really is. Both the judges in this court that I covered are they're just, I don't know, they just seem like good people. So it's always fun to get a good one. All right, that's the show though, guys. Thank you so much for hanging out with me tonight. I appreciate it. Thank you guys for the super chats, the membership milestones, the gifted membership. You guys are awesome. I have us set up to raid Lone Wolf, so we're gonna go jump over and say hi to him. Jen Hardy is also live. If you want to go hang out with her, she is also live. So yeah, those are the options that I see on my list. So you pick whichever one you want to go to. But I will see you guys tomorrow. Well, I hope so. With the judicial conference going on. Yeah. It might be tough. But I'll do my best to try to put together a show for us tomorrow night so we can hang out. But yeah, until then, that's all I got. I don't know. I really need to get better at trying to close out a show because I'm terrible at it. All right, you guys are awesome. Until next time, bye.